Evergreen Apartments versus Matthew Chavez.
Morning, Your Honor. James Fink for Plea.
Good morning.
Good morning.
All right. And where are we on this case?
Yes. ESA paperwork in, he got it approved, the ledger's been adjusted to reduce pet rent from the date he turned it in. The current balance including costs is $1873.61. I don't think there's a tribal issue, but that's up to you, sir. 1873.61.
Sir, your position.
Yeah, I don't see where they took the pet run off.
Yeah, great. It's minus 17 monthly pet rent. It's prorated from the date. It's $30 a month from the date you turn your paperwork in. $30 a month. You turn your paperwork in, so they should about 17. And you won't get charged going forward.
Okay, well, I have to, well, my Evelyn housing worker, she said she needed a total for what I owe, so she can try to get.
1873.61 is what you know.
That's what I'm.
Okay. All right. So
She's not here, I guess. She said that she needed a total so she could try to get some different organizations to
try to help you out. Okay. So let's do this. If I were to issue it, today's 22nd, right?
Yes.
Sorry, we're going to be on the 2nd. Here's what I'll do. I'm going to find no tribal issue after hearing in this case. I'm going to issue a judgment for that amount. Okay. At the same time, give your worker time and you to work it out. No writ until the 9th of May. All right.
Okay.
All right. That extends your time a little bit, about a week or so out.
Must have been a judgment, Your Honor.
All right. And you were able to get the Humane Society took care of you, right?
Very next day. Thank you very much.
You're welcome.
Thank you, sir.
Thank you. Jerome versus Cassidy. Counsel, I want to state your appearances, please.
Your Honor, Agnes Cooper, appearing on behalf of Alec and Carolyn Jerome. Morning, Your Honor. Francie Nova, appearing on behalf of Barry Cassidy.
Alex on behalf of Cambridge Interpolance.
And Gail Rose on behalf of Paul Cassidy.
All right. Okay. And where are we? I'm almost afraid to ask, but.
Your Honor, we've attended mediation. We have continued discussions since that time, but as of right now, we're unable to resolve the matter on our own.
What's that mean?
I think it means we need a trial date, Your Honor. We need a scheduling order so that we have time to file an answer and a counterclaim because we haven't done that with the fourth claim, the fourth case.
Oh, of course, because when someone ghosts their court date, the universe just loves handing out instant wins like candy. No questions asked, no mercy given. It's impressive how effortlessly justice moves when one side decides to play hide and seek. Why bother with hearings or explanations when you can just slam down a judgment quick and dirty because accountability is clearly overrated? Bravo to the master of swift verdicts, because who needs fairness when you can have efficiency?
Oh, I know what,
Okay.
but that's because you guys told me you'd be settled.
So
I didn't.
Then we're going to file a motion to remove it to the circuit court after we get our answer and counterclaim.
Why don't we do this? I'm going to pass the matter, and then I'm going to meet with counsel and back, figure out exactly where this thing is and what we're doing on this. Okay?
Thank you, Your Honor.
Thank you. State Solutions versus Daryl Daniels.
Good morning, Your Honor.
Good morning, sir.
For the record, Neil Chan is appearing on behalf of Plea. Good morning.
Good morning, Mr. Daniels. How are you?
Good.
Okay, where are we?
Your Honor, we've agreed to the terms of a consent order for conditional dismissal. It indicates under further conditions, paragraph 3, that the defendant shall vacate the premises on or before May 23rd, 2025. Plaintiff shall reimburse the defendant for the rent paid in the month of February in the amount of $500. Return the security deposit in the amount of $650 and pay for moving expenses not to exceed $500 upon vacating premises. Paragraph 4B has been checked. I will explain the court rule 4.201J to Mr. Daniels, and then he has 3 business days to ask for the hearing date. If you believe you should not have entered into this, Mr. Daniels did sign the consent order.
Sir, is all of that correct?
Yes.
Regarding that conditional order dismissal, do you have any questions whatsoever regarding that? No? All right. You have no problem with me signing it? All right, great. Have signed it. Thank you guys for working it out.
Thank you, Your Honor. Have a good
Thank
day.
you. Take care. Town Center Place versus Jacqueline King. She can have a seat there. All right. This is your motion.
Your Honor, we request per COD that Ms. Payne be granted an additional 30 days to move. As per the terms of the COD, her condition was to show that she had been looking for new housing. I provided a letter from Ms. Little from Housing Europe Senior showing the properties that she's applied to. Since that letter, she's even applied to even more. She's been accepted at about 3 of them, but she hasn't had her interview yet. And then even after she has her interview, there's no guarantee that the apartment will be ready in a certain time. And I also filed a
So when are her interviews?
Would you mind if Ms. Little comes up?
Yeah. That's fine.
Take the name of the record.
Okay.
The classic courtroom dance. Promises of settlement, motions to file later, and the judge patiently playing the wise mediator while everyone tiptoes around like it's a delicate game of where's the deadline. Meanwhile, the judge just nods along, signs consent orders like a pro, and keeps the show moving because, hey, why rush when you can let the legal circus unfold at its own charming pace? All hail the master of patience and paperwork.
So Ms. King has been selected for 3 apartments. And one specifically, she's in the process of an interview. We don't have a date yet because we're still seeing paperwork. It's a really long process to get all of this done in such a short time frame, honestly, to get everything done. And so I would think the interview would be next week or so. She just needs to get down there and get it scheduled. I mean, the apartment that, have the biggest lead on isn't one we really want her to go to, because obviously in this short time frame, she's not going to get a great option to move into. So it'd be nice if we got her from the others, but we'll probably have to.
Okay. All right. Thank you. Response.
We're asking, for a written conditional order of dismissal to be enforced. Part of the conditional dismissal order was that she paid rent, she paid full rent, she paid time rent. And we've informed her, as you see in the answer, of she recertified, her rental increase went up to $270 a month, and she's still been paying $247. So she owes currently $79. And she was supposed to pay on time, full amount of rent stated in the conditional dismissal. She has not.
she's been informed that she had been paid by a letter and less both times, and she has not submitted any extra money.
Okay.
Yeah.
Your Honor, the ledger that plaintiff added, submitted with their answer is not the ledger that they seem to have removed all of the hat payments and Ms. King's credit, and produced this ledger that they claim is what she has paid. However, I've asked on more than one occasion for a complete ledger. This ledger starts in April of 2020. Ms. King has lived at Town Center for at least 8 years, and she's been in this new apartment for.
When was she recertified?
She was recertified.
I think it's in April or March.
It was January 16th, 2025.
January of this year.
Yes. The effective date was March 1st, 2025.
Of the rent. So it's March and April. That
And
Go ahead. Your Honor, as part of the terms of the consent order for conditional dismissal, we were to wipe her ledger as
I recall.
Did that. So before that date, it shouldn't be in controversy here.
Well, that's what I was curious about.
Your Honor, the reason it's in controversy is because they wiped her account and included her February's payment, hopefully it's February 7th, and they wiped her credit. Now, what my understanding of wiping her account was to remove the charges that she had since.
She was to zero out, that's what was supposed to happen.
Okay. So she gets zeroed out the credit that she has and the payment that she made for February? Because if you look back to prior to them filing this case, she had been paying $200.
I'm not relitigating the case.
Okay, well, Your Honor, the COD says that she abide by the terms of the lease. This is subsidized housing. Paying rent late, which she didn't do because she paid on the 5th, and they didn't process it until the 6th. And not paying the full amount of rent is not a eviction cause for subsidized housing. They are required to offer payment arrangements. The goal is for subsidized housing.
The classic courtroom dance. Promises of settlement, motions to file later, and the judge patiently playing the wise mediator while everyone tiptoes around like it's a delicate game of, where's the deadline? Meanwhile, the judge just nods along, signs consent orders like a pro, and keeps the show moving because, hey, why rush when you can let the legal circus unfold at its own charming pace? All hail the master of patience and paperwork.
She entered into a COD that she was going to pay her rent timely.
No, COD says she would not violate her lease. This is not a non-payment of rent case. Never has been.
Does she have the 79?
Yes, Your Honor, she has $79.
Then why are we arguing? Why doesn't she pay it?
Because she has credit on her account, Your Honor. It's not fair for them to keep the credit, and they reverse the half payment at a different
All right.
time. And
This is ridiculous.
Exactly.
No, it is simply what your argument is ridiculous. Because what I'm going to do is she was to abide by the terms. She has to pay her rent on time, got her account zeroed out, gave time for her to find new housing, gave an opportunity to then come before the court and ask for additional time if she showed that she was doing that and complying with the COD. She's not in compliance with the COD. I'm going to deny the motion to extend the time.
Your Honor, thank you. Your Honor, how is she not in compliance with the COD? It doesn't specifically say that she has to pay her rent one time.
It
or the
does.
full amount. It does.
It does.
It has things for late payments. It has other things that if you go to paragraph 23 or whatever, it lists the things that you can terminate. Do you have?
I'm sorry. Your Honor,
Yes.
the second line from the last line. It says defendant will pay March and April rent at normal time. Your signature is right here.
And she pays on the fifth.
She did not pay her full rent, ma'am.
Okay, but she paid on the fifth.
She didn't pay her full rent. We can go round and round in circles. Motion denied. Motion denied. I'm not going around and round in circles on this.
So Your Honor, we'll submit a writ.
Thank you.
Thank you. You have a good afternoon, Your Honor.
Yeah, too late. Good, thanks. All right, he's back in Zoom, so let me deal with him and then I'll deal with the gang of four. Court recalls the case of S&C Holdings versus Michelle Stacy.
Ready, Your Honor. Tracy Thomas, appearing on behalf of plaintiff.
Hello, your name?
Michelle Stacy, representing himself.
All right, and this is your objection to garnishment?
Yes, sir.
Okay, and what's your basis for the objection?
I haven't received any information to defend myself against the garnishment before the garnishment has been issued.
What do you mean by that?
I have filed my state tax return, and I received a letter from the state saying that I will not receive my tax return because it has been given in the month to SC Holdings.
Correct.
So there was paperwork saying that I could defend myself.
Judge clearly running the show like a pro, cutting through the endless circular arguments with zero tolerance for the usual, but she paid, no she didn't dance. When the defense tries to spin tales about credits and timing, the judge is having none of it, firmly calling out the failure to meet basic obligations and shutting down motions faster than you can say lease violation. And when the defendant complains about not getting paperwork, the judge just expects everyone to keep up or get out. No nonsense, no hand-holding, just pure courtroom efficiency at its finest.
Where you could say that again. That you could defend yourself to get the tax return?
Yes.
Well, I'm not.
The same thing as getting garnished from a paycheck. Where I have a minute to say that I still need a paycheck. Is that the same thing as getting garnished from my tax returns? That's my understanding.
Well, I guess I'm unclear as to what you specifically wanted, because what I have here, ma'am, is that on June 18th of 2023, there was a money judgment in the amount of $3,381.14. Okay, there was a money judgment. So that would have been your first notice that there was a money judgment against you. Okay. The garnishments are usually sent without notification to the party, particularly tax garnishments. Okay, so I think you may be looking for something that really doesn't exist. Certainly with regard to wage garnishment, theoretically, you get one of those without notice too, but usually the employer or whoever is issuing the check kind of notifies you that something is going on. They may or may not, right? But in this circumstance, your notification to challenge the withholding of your taxes, you may be able to take it up with the state, but certainly as I look at the file and have reviewed everything, there's not anything improper in terms of what the plaintiff in this case has done in terms of garnishing your taxes.
I apologize for the time.
You apologize for?
Wasting time.
Oh, no, don't apologize for that. That's fine. But as long as you understand what I'm saying, I just want to make sure, okay?
Please, could you tell me who exactly you're representing? Are you representing someone in Milan to come see Belleville?
Say again?
I don't know what SC Holdings is. I owe a lot of people a lot of money. I'm 6 to 8 weeks away from filing bankruptcy. So
I got you. Was it a...
Your Honor,
Go ahead, mister.
it's her former landlord. S&C Holdings is Park Lane Apartment.
Okay, so that's the minor complex. Thank you so much.
Okay, got that? Okay. All right. So your objections are denied. Okay? Thank you.
Thank you, Your Honor.
Thank you, sir.
Judge handling this like a seasoned pro, breaking down the confusion with crystal clear explanations while patiently untangling the defendant's tangled questions about tax returns and garnishments. No fluff, no beating around the bush. Here's what happened, here's what the law says, and no, you're not getting special treatment just because you're confused. Even when the defendant throws in a "sorry for your time," the judge keeps it cool and respectful but firm, making sure everyone leaves with zero illusions about how this works. Just straight-up courtroom clarity served with a side of patience.